Welcome to Secnap's Breakfast of Compliance Champ Series. We've created a series of videos covering hot topics surrounding data compliance, including PCI, GDPR, SOC, and overall cybersecurity. This video, presented by Aldo Leyva, attorney at Baker Donaldson, will be discussing how upcoming changes to U.S. privacy laws inspired by GDPR can impact U.S. business. Aldo has practiced law for over 15 years. He represents and counsels diverse clients on rapidly evolving federal, state, and international data security and privacy laws, including HIPAA, HITECH, FCRA, FACTA, and EU, as well as Latin American data protection laws. Let's listen in on Aldo's presentation.
Up to Secnap for putting together this great panel. Thank you. It speaks to the complexity of what all businesses are dealing with today, right? It talks about, you had 4 different viewpoints talking about one common problem. How do you manage all this information? What are the best ways to do it? What do you even have to do? What are you supposed to do? The answer is that from a legal perspective, the law is still catching up, right? The law is several years behind where the tech is, and as tech continues to exponentially grow and change, lawyers and legislatures are going to have a lot tougher time of keeping up with it, right? So I would argue that right now what lawyers need to do is basically keep an eye on what's happening with technology. Track not just what's coming on board as far as regulations, but track what's happening in the world of innovation, what's going on, where are things going? That way you can best advise your clients as to what's happening. So what we saw coming for a while was GDPR. And let me explain what that is, because I have to tell you, the marketing departments of every compliance company has done a great job as far as talking about GDPR, not so much as explaining what it is and whether it even affects you, right? So hopefully we're going to get to that, and we'll cover that today. The Florida bar rules do require me to say that basically it's just for informational purposes. Don't take any slide or take any information I'm going to give you today and assume, okay, yeah, I saw the slide, we're okay. The lawyer said so. The lawyer today is just telling you, providing an overview, right? And if anything, it's just to provide you a very broad scope as to what this law is about, and most importantly, how the GDPR is going to impact and is impacting U.S. legislation. Just this morning, Tim Cook of Apple was speaking in the EU and basically announced we need a federal standard for privacy in this country, in the United States. And I agree with that. Why? Because countless times clients are asking me, what am I supposed to do in the event, forget about compliance, let's talk about what happens in the event of a disaster, a data breach. They have to comply, they don't even know what to comply with. Right now, thanks to Alabama, who just adopted data breach notification statute a few months ago, we have 50 different requirements out there. So depending on where your data sits and whose data you're managing, you may have to comply with 50 different laws. Right? And good luck finding a lawyer who's going to be able to cover all those states, because I have to confess, there's some places where I don't even know what's going on over there. So it's a rapidly evolving area right now, and that's why it needs to be closely monitored. So what is the GDPR? So it stands for the General Data Protection Regulation. And by the way, don't worry about copying and reading the slides. I'll provide them to you if you're interested. But the bottom line is that let's ask why where this came from and what's this all about, right? So back in the 1990s, and think about where tech was in the 1990s, right? Dial-ups, right? The green screen, the matrix, okay? That's when these regulations first came into place, right? The EU privacy, the EU directive came out in 1995, and at that time they were dealing with how to manage information that was only starting to be uploaded, right? We didn't have social media and all those things yet, okay? So that was just beginning, and those regulations captured that perspective of how data should be managed back then. This is where it affects everybody in this room, and this is the first question you have to ask yourself. Does this even apply to me? But you also have to think, does it apply to any of my customers? Does it to any clients? That's the first thing you need to do. So who does it apply to? It applies to any organizations that are located in EU member states. So easy one, if you have a subsidiary that's in Spain or France or Italy, then yeah, you're going to have to have a compliance program to deal with GDPR. Why? Because They can get their hooks in you. They can get their local regulators there, and they can impose fines and penalties against you. So that would be a real basic one. It also applies to any organization outside the EU member states that offers goods or services to EU citizens, even if no payments are received. You're not even selling anything yet. You're just doing marketing, right? You're just collecting data for emails, et cetera. Or you monitor the behavior of EU citizens. That could be anything. That could be you have webcams or cameras, traffic cameras, et cetera. So there's a whole lot of different ways by which, if you are somehow touching that data, if you are either processing it or responsible for the decision to even collect it in the first place, you may be subject to GDPR. So I was talking about the penalties before. A violation can cost up to $24 million, or 4% of the violator's annual global revenue, whichever is higher. All right? This is why you've been flooded with those notifications, right? Because the stakes are high. As of May, the first investigations are being undertaken. Right now, we don't have any fines or penalties imposed yet, but we anticipate that probably by the end of the year or early 2019, we're going to start seeing some indication as to where they're going with this, right? How aggressive are they going to be? Is it going to be anywhere near 24 million, or is it something more reasonable? Are they going to go after smaller companies or larger companies? Probably they're going to start with the larger ones as an example. There's general definitions. A lot of this is migrated over from the old EU privacy directive. Basically, there's three players here. One is the data controller, the one who makes the decision, right? We're going to collect this data. This is what we need to do. We've made a business decision that this is the data that we need. To the data processor, this is the service provider. This is the company either or the department or an independent contractor that's going to process the data for us, right? For us to be able to utilize it. Personal data basically talks about any information relating to an identified or identifiable natural person. And let me get into that, because that's a much broader definition than it is under US law, or at least it was until California chimed in a few weeks ago. Personal data includes, for example, an email. If you collect someone's email and their name, that's personal data. You're thinking, oh, social security numbers, you're thinking driver's license numbers, date of birth, biometrics, something like that. No, so it's a lot more rigorous as far as how that is. And let me pause here and kind of address a little bit as to the why, right? Why are the Europeans providing a much more aggressive and expansive definition of privacy and personal information? It's largely because of the very different history that Europe has had from the United States, right? Europe has encountered fascism, communism, centralized governments that use data to kill people, right? That's their history. It's happened again and again in Europe. That's the backdrop. That's the cultural mindset as to how they view privacy, right? Here in the United States, thankfully, we've had a very different history with our own issues, but the point is that, we are always concerned. We're a country that's wary of government intrusion and wary of government controls, but not at this level of we're so worried about data privacy. The reason being is that Google's created this entire industry based on what? Volunteering your personal information to them for free, okay? But things are changing now because you see that consumers are demanding increasingly more and more rights as to how to control their information. You're going to see more of it. So this is the dangerous slide, okay? Do not use this as your self-assessment, okay? But these are just some general ideas as to things to consider as to whether or not a U.S. company is subject to GDPR. As I said before, if you're present, you're a data controller in the EU, yeah, you're going to be likely you're going to be subject to it. If you're in the EU and you're a data processor, yes. Do you have any subsidiary that controls or processes data in the EU? Yes. Do you have an online presence? And I say maybe there. So it depends on whether or not you have any marketing or any communication intended towards a European audience, right? And I think eventually, we were talking about compliance before. I think one of the ways, you see all those websites that say this website is not for children under 13, right? That's because of the Children Online Privacy Protection Act. I think that you can do the same thing on a website. This website is not intended for European audiences. That's another way to try to notify everybody. Are you advertising to them? Are you offering terms in euros or pounds? Right? So those are things that will be determined on that side. Are you dropping cookies or otherwise tracking the behavior of the residents? Right? Anything like that could place you under that. And another way that comes about could be contractual. You may have a client or a customer that says, hey, I'm doing a lot of EU data. Just in case I have a little bit of data leakage or somehow you're going to be involved in this, I need you to sign an agreement that you're going to comply with GDPR. Right? Otherwise, we can't do business. So you may have a contractual obligation to comply with GDPR, even if you're nowhere near the EU, because it all depends on whose data you have access to and who you're working with. It's a wide range of rights that they have in Europe. You have a right to data portability. That means you can get a copy of your personal data and decide, okay, I don't want it here anymore, I want it over there. Right? Right to erasure, right to be forgotten. Right? I want American Express to forget that I ever had a card with them. Good luck, right? But that's their right. You can ask American Express to basically wipe you and erase you. Now, practically, how do you deal with backups and tapes? And it's a lot easier said than done. Right to object to profiling to automated processing decisions. In other words, you have agency. You decide on how your data is processed. You can place limitations on it, right? So in light of these rights, what would a company that's subject to GDPR consider? Implement their processes and infrastructure to address these rights. Right? You got to be able to guarantee that if you're going to do business in EU, you're able to basically afford people their rights. Consent issues, we talked about that before. It has to be very affirmative. It can't be just, oh, well, they never said no, right? Or pre-checked boxes or inactivity. We sent them an email and they were never answered. I guess it's okay. No, you need to have something in writing where consent is freely given. And it has to be meaningful consent, which means that they have to understand. You have to put it in a certain language that is understandable to the user. It has to be directed towards that consumer in that market. Okay? So again, you want to identify a processing that's legitimized via consent, and obviously also collect that and document that. Implementing reasonable security measures. Right? So this is the first time, and again, we're going to see more of this in privacy laws, because there's obviously a connection between security and cybersecurity and privacy, right? You can't have privacy if you don't have a robust cybersecurity system in place. So the magic word here is reasonable, right? And then people say, well, what's reasonable? And the answer that every good lawyer tells you is, it depends, right? And the reason being is that it depends on what your business is. It depends on whose data you're hosting or using. It depends on what specific threats you are subject to because of the infrastructure that you've selected, right? What operating system are you on? What software do you run? It depends. And what's reasonable. So this is going to be very much like medical cases. Okay, what was reasonable for that surgeon to do? What's the prevailing standard of care that the surgeon should have used in doing the surgery on the patient? And that changes from location to location, from condition to condition, right? So that kind of very wide net of things is going to be what's at play. So, what's reasonable and what do I need to do? It's not an easy answer, and that's why that's why you have 4 different people up here from widely different areas. It's a complex issue, right? But that's the world we live in, right? It's complex. Data mapping, you have to maintain records of your processing activities. That means you have to be able to show where the data go, where did it go, what servers does it go to, who's got access to it. And most importantly, you've got to have a good map to make sure that you're plugging all the leaks, right? Data protection by design. And this is huge for Internet of Things. The concept being is that you have to, when you're designing a product or a service or something new, you have to incorporate within it privacy from the beginning, okay? You can't just add it on later. Oh yeah, well what about privacy? Privacy needs to be baked in, all right? And there's a concept out of Canada called privacy by design, so it's very well developed and there's a lot of resources out there about it. But basically, you have to minimize the data that you're collecting. Why are you collecting? That's one thing I always tell my clients, right? Well, why are you doing this? Do you really need to do this? Because that's just another risk by you just having it. We're talking about the boxes full of credit card slips and things like that. That's a risk. Data protection impact assessments. So they have to continually, depending on what they're doing, they have to assess what impact this could have on people's privacy. So anytime you change your processing procedures or you have a new idea, you need to do these impact assessments. Kind of like environmental impact, except for privacy. Accountability. You have to make sure that you're able to demonstrate everything there. You may have to have a data protection officer to oversee the process for you, right? Depends on where your situation is. I'm going to skip over because I just realized I'm running out of time. But basically, the EU data breach notification requirements is now 72 hours. That's fast, right? So you got to be ready to do what happens here. So as I said before, it's only a floor. Investigations are underway, but how does this impact now and what does it have to do with California? This is the law. Everyone put in here on their questionnaires GDPR. Cross it out and write down CCPA. That's what you should be concerned about. Okay? This is a California law. It just passed. It goes into effect in 2020. And it is basically the US version of the GDPR. It imposes several of these requirements that we were talking about before to any company that processes data for California residents. So right now, yeah, so you guys are fine. So, so you've got a choice. Decide, do I really want the California market that bad? But wait, there's more. California is the leading, historically, it's the leading legislature that's created privacy laws, right? It all starts in California and then slowly migrates east. So this is coming. This is coming. It'll impact more US companies than GDPR, obviously. The effective date is January 1, 2020. So you got, whatever, 13 months, give or take, to comply with it. And it's $7,500 for each intentional violation. I appreciate the intentional. No, seriously, because if it were just negligent, then it could be anything, right? So intentional, okay. We can work with that. So they define personal information that's similar to GDPR, but they link it to households. So it could include a physical address that's not directly linked to an individual. So think about that. We don't have the name, we just have someone's address. That may be something you have to protect. You have to inform consumers. You have to disclose categories of how their data has been used for the past 12 months. Clear and conspicuous opt-out link on the site. You have to have a button on your website that says, I opt out, I don't want anything anymore. Not email, not text back opt out. No, a button on your website. Okay? Right to be forgotten. That's straight out of the GDPR. All copies purged. So, getting into this is the one that you should be concerned about, because again, and this is what's coming. So what comes next, and I'll close out here. The push is now, as Tim Cook has called for, it's going to be for a federal statute, because this is crazy, right? Now you're dealing with all sorts of statutes from all over the country. It's a very decentralized way of managing privacy, right? Because there's student privacy laws, there's health privacy laws, there's financial privacy laws, there's children privacy laws. It's all over the place, right? So it's a challenge even as a lawyer to get your arms around all the regulations that you're subject to. So the idea is for simplification by something called preemption. A federal law that preempts all state law, right? That's what Amazon's pushing for, that's what Facebook's pushing for, that's what Tim Cook's talking about. There is an appetite for that in the Congress, and the Senate wants to adopt that. We'll see how that goes. That's one thing that we're monitoring. But definitely, the take-home message here is take a look at how your data is being used. If it touches Europe or if it touches California, you definitely should consult with a lawyer to tell you what to do. Thank you.
So we're going to take a few questions.
So you mentioned that there is a push towards a federal standard here, a federal statute. Is there any sense that there's a preemption challenge here based on the CCPA, the California Consumer Privacy Act?
So the preemption is a misnomer in the sense that it establishes a floor. Many preemption laws, and under the concept of preemption, a state is free to adopt a higher and stricter standard than what the federal minimum is. So California can still say, that's fine, but you still have to have that button, even if the federal statute doesn't require it. So there's still going to be some tweaking by the individual state legislatures, but it also depends on what degree and how much preemption the Senate and the House are going to push through it. And again, this is something that's still being just considered. No one's posted a bill yet.
I guess my question actually is whether there's a sense that the federal government will decide that the CCPA is overreaching because now it's regulating interstate commerce.
That's going to be a Supreme Court case ultimately, right? It's going to be that issue. Those challenges will come into place ultimately. And that's also what the big tech giants are concerned about. They were very much against the California law, right? Even though they are based in California. It tells you just how much influence they actually don't have, right? Because you would think this law would never have made its way out of the legislature. But
So there are existing cases then?
There will be. Once you get the federal standard versus the state standard, that's when the litigation is going to come out. Just like environmental protection laws, that's how it works out. So the answer is we don't know yet.
Several questions. Go ahead.
So I guess if you're a startup and you're going to get into, the new era, is there a way to say, hey, we're not going to support GDPR, and just like a doctor's office says we don't have malpractice insurance, come at your own risk? I mean, is there such a thing
Well, you
that
can't
you disclose?
you just can't say I'm not going to look at it. I'm not going to even think about it.
Right, but I'm saying
it
if I said
depends.
join my social media platform.
You have to design intentionally your way of doing business, right? It's going to be a
Around
combination
GDPR.
around a way that avoids that kind of issue,
Catch.
right? But it can come up unexpectedly. I had a plastic surgery center contact me for GDPR. I'm like, what are you guys talking about? We've been marketing to Spain, right?
Hey, good morning. With Brexit, how does that affect business from a UK perspective?
So UK is still adhering to these standards. In fact, the UK already initiated an investigation against U.S. companies already as far as their privacy violations.
And
So
my-
they're very much still in the game.
Thank you. My second question, my company writes software that processes payments for companies, no matter if it's a little credit card machine to a server. I kind of have a good, high-level understanding how, from a personal user, somebody who processes a payment through my system or through my customer systems, how this could affect it. My question is regarding administrator accounts. So this isn't somebody who's necessarily using the system. This is somebody who's managing the system. Does GDPR and GDPR and these types of privacy, do they play into that? Like people who manage the systems and because they have an email address and a name and whatever else they might have, a recovery email.
Arguably, I mean, certainly I can't brief you on it, but just looking at a very generic viewpoint, that could arguably be a data controller. That's a person who makes decisions on data processing and how it's done, the whether, the how. That may place them under that.
We're going to take one more question, and then we're going to have a short break before we set up for the panel.
Okay, so I
Just sold 2,000 endpoints, a solution for a client in the Netherlands, but I did it through one of our vendors. So they're going to write up the quote, we're going to add up our percentage, and then we're going to do it on our paper. Do we need to comply with GDPR?
Where are all these players involved? What's their involvement?
We're in
with EU?
Austin,
Okay.
the other company's here in Florida, and the client is in the Netherlands.
Talk to a lawyer.
Okay.
Thanks for watching this session provided by Secnap Network Security. A link to other Compliance Champ videos in this series can be found in the description of this video. If you like this video, please give it a thumbs up. If you'd like to see more videos like this, please subscribe to our channel. For over 17 years, Secnap has enabled clients to conduct business effectively and securely on the internet. Our security as a service solution, CloudJacket X, features patented technology in combination with security experts that manage, detect, and respond to ongoing cybersecurity threats 24/7. CloudJacket X eliminates labor-intensive log analysis and alert fatigue, allowing our clients to focus on their business. Secnap also provides regulatory compliance and information security assessments. For more information, visit secnap.com.